Yes, that's up.
Lords, I'm most grateful to be given another half hour, but I plan not to use it and to be as swift as possible.
Yes.
Over lunch, we have refined what we have left to say to the following. Number one, we are content with the court approaching the case on the court's own construction of section 75(1)(b). It appears to us to be a clear and clean way of resolving the question that does need resolution of the interpretation of that particular provision. Secondly, we are not content with the court adopting the respondent's reading of section 75(1)(b) or of the statutory scheme or of the respondent's reasons for that reading. And the reason we are not content with that is because of the potential for it to have unanticipated implications for other unrelated parts of the statutory scheme that cannot be foreseen in their totality at this stage. There is one good example, which is guardianship and changes of status from detention under section 3, a civil section, to transfer into guardianship. This was the case in ADA 243 of the authorities bundle, where Upper Tribunal Judge Jacobs found that a patient who had applied to the tribunal while she was detained under section 3, but then before the hearing of that application had been transferred into guardianship, the judge found that the tribunal's jurisdiction survived. The significance of this is that guardianship applications to the tribunal are made and determined under a different subsection of section 72 than detentions and community treatment orders. Subsection 4 rather than subsection 1. That was why Upper Tribunal Judge Jacobs at paragraph 10 on 245 was concerned to point out that a tribunal's jurisdiction is different from the powers it has within that jurisdiction, the latter of which may change if the law changes or if the circumstances of the case change. Now, at paragraph 46 of the skeleton argument for the respondent, the point is made that section 75, this is, sorry, page 59 of the core bundle, that section 59(2) is intended to deal with the case of a person who has not been recalled at the time the application is determined, which is demonstrated by the powers that the tribunal has on that application. Of course, this was touched on this morning. We say that that overlooks the principle identified by Judge Jacobs at paragraph 10 of ADA. But it demonstrates the potential for, if the respondent's reading is accepted, unintended consequences follow to other parts of the Act. Guardianship is the example because the powers the Act gives to the tribunal for Section 3 detained patients and guardianship patients are very different. One of the things that the tribunal needs to determine under Section 72(1)(b), which we've seen, which would apply on the respondent's reading because that was the section that the patient was detained on at the time she made the application. One of the things the tribunal needs to decide is whether the patient requires to be detained in hospital for appropriate treatment. A guardianship patient is not detained in hospital. Section 72(3) allows the tribunal, where it does not discharge a patient detained under Section 3, to recommend that a patient is transferred into guardianship. That is obviously meaningless where the patient is, at the time of the hearing, under guardianship. The respondent asks the court to make a decision in this appeal on the basis that the patient's status at the time of making the application must determine how the tribunal adjudicates the application even after a patient's status has changed. The potential for a butterfly effect, as it were, is demonstrated by this situation with the guardianship patient, because if that reading is accepted, it affects ADA. And so, for example, a vulnerable patient detained under Section 3 who applies to the tribunal under Section 66(1)(b) but is then released from detention into guardianship before the application is heard, will not have access to a tribunal making a meaningful decision about her status at the time that the tribunal is heard.
Judge Jacobs had not forgotten his previous decision, and he cites it in the present case.
Yes, there's a lot of these cases are the decisions of Judge Jacobs, and they feed into each other. So, in short, the point that we make here is that the Mental Health Act is an intricate and complex machine. That concerns intensely vulnerable people, as well as people who pose a risk to the public. We have identified, because it's in ADA, one potential butterfly effect from the respondent's reading. But there may well be others. And our concern is that pulling on a string at one end of this complex machine may have completely unforeseen effects somewhere completely different within it. So for that reason, we say that this court's interpretation of Section 75(1) is correct and is a narrow and right way of resolving this claim. Going further by accepting the respondent's readings and arguments is both unnecessary and has potential unforeseeable risks. And My third and final point this afternoon is that the respondent's argument that this appeal is academic is not material and not helpful. This appeal was academic at the time that permission was granted by Lord Justice Dingemans. But it remains compelling as something that needs to be determined and resolved because a statutory interpretation is needed. That's the point. And those are my submissions.
Thank you. Thank you very much. Mr. Percy? Ms. Ayres?
My Lords, the case is not quite what it was this morning. It may be helpful if I deal with the development in the case first, because as my Lords have appreciated, the crux of my submission is that there is no problem here by virtue of the existence of a reference. My learned friend identifies problems that may occur following a reference and a subsequent conditional discharge. And while that is not the situation that the appellant is in, seeks to create in aid for a reinterpretation of the legislative scheme, and it's therefore, on any view, fundamental. As far as the Secretary of State's position is concerned, I have sought to take instructions over the short adjournment. And the Secretary of State for these purposes embodies the law in a number of ways. First, he is a party to proceedings before the First-tier Tribunal and the Upper Tribunal and in any subsequent appeal. And secondly, of course, he has overarching policy responsibility for the courts and tribunals generally. Insofar as the Secretary of State is a party to proceedings, my instructions are that he takes no issue with the interpretation that my Lords have proposed to Section 75. In other words, that a reference survives a re-release such that there is a review even after the patient has been conditionally discharged again. But the reason that I set that out in the way that I do is to urge a note of caution, in the sense that, as my learned friend has referred to, proceedings before these tribunals are more of an inquiry than inter partes proceedings, and the Secretary of State is not routinely represented. And as such, the impact of my Lord's decision will not be on the Secretary of State, but on the court's system. My Lords have seen the range of issues on which Upper Tribunal Judge Jacobs has given decisions, and I am not in any way suggesting to my Lords that I have the same level of expertise in these matters as he does, and I am therefore wary in urging your Lordships to adopt a course which does not arise strictly on the appeal, and which may have ramifications which have not been foreseen in the limited time that there has been to take instructions. So the Secretary of State's position is to acknowledge that the interpretation that has been articulated is an attractive one, but nevertheless to raise for my Lord's consideration whether it is a matter that needs to be decided. As far as the process is concerned, I may perhaps be able to add a little bit of meat to the bones. Two issues which are slightly different in analysis arise from the Court's proposed interpretation of Section 75. The first is what happens if a recall is effected and the patient is re-released before a reference can even be made to the tribunal. The second is what happens if the recall is effected, the reference is made, and thereafter the patient is released prior to the adjudication by the First-tier Tribunal. The former, on instructions, is highly unlikely to happen in practice. Referrals are generally made the next day. What happened in this case was that a decision to recall was taken on Friday the 1st of, I think it's March 2024. The warrant was executed, the patient was actually detained on the 2nd of March. The relevant team were notified that that had happened after the weekend on Monday the 4th, and thus the reference was made on Tuesday the 5th.
Is there any guidance or practice note or protocol about the speed with which the reference must be made?
There's the case, Rayner. So tab 9, my lord, page 223. And this was a case in which exactly the scenario that was posited this morning occurred. That is, the Secretary of State, through oversight, failed to make a reference when he should have done. And the court therefore looked at the situation under Article 5. I'm sorry, I think it may be 213 in the up-to-date. So I'm looking at paragraph 24, which spans pages 212 to 213. And that deals with what the reasonable time requirement requires as far as the speed of the reference is concerned.
A few days.
Days, not
Days, not weeks, normally a few days.
Yes.
Yes. Case specific, but that's the guidance, and as I say, generally within a day in practice.
Who actually does it then? Who actually, is there a department within the,
Yes.
how does it work?
The Lord will allow me to open recent emails. I don't have information about the particular department. If a note would assist.
It doesn't matter.
Not really. It's only my Lord's curiosity.
It's officials
What actually happened.
working for the MOJ.
It's delightful when counsel refers to the Secretary of State and as though, in this case, Mr. Lammy or whoever it was a year ago or 2 years ago had anything to do with it. But
Yes.
we would quite like to know, is there a specialist unit within the MOJ?
I'm sure I can obtain that information.
And presumably following Rayner, the Secretary of State will set up a procedure which would comply with this. So
Yes.
presumably was in the Home Office and has now moved to the Ministry of Justice.
Yes. I'm told it's mental health case section or mental health case work section.
Yes.
Okay.
Yes, in the Rayner case, it was the Home Secretary at stayed with the Family Division and had become Justice Secretary by this court.
Yes. I would be wary about assuming that departmental arrangements have been the same since 2005. Let 9.
No, quite. Anyway, I was brought up on the constitutional theory that there is only one Secretary of State.
Yes.
When it was a member of the Cecil family in the days of Elizabeth I.
Would be news to some of the current Secretaries of State.
Yes, all right. So now, what do we get from the Rayner case apart from Lord Justice Keene's observation within days, not weeks, and normally within a few days?
Well, the other point that we get from it, and it's an entirely separate point, is that it helps us with Article 5, because my submission is that is a red herring in this case, in the sense that my learned friend has sought to pray and aid the fact that patients remain liable for detention, but it's very clear that what Article 5.4 requires is a speedy review of detention, which is detention within the autonomous meaning of the Convention. And therefore, while of course I accept that there needs to be a review of detention while a patient has just been detained and is still being detained, I don't accept either that Article 5.4 itself requires that to be maintained after the patient has been released. That's the equivalent of requiring a bail application after bail has been granted. Article 5.4 doesn't require that. Remedies in damages would be dealt with separately.
What about the impact of 75(1)(b)? In the hypothetical example that a patient is recalled and then discharged immediately before the referral, if the interpretation we've put to you is not correct, doesn't it then follow that there won't be a review by a tribunal until the expiry of the Section 70 period, because it goes back to square one?
Well, it may do. The first point to make is that Article 5.4 does not require one, because just as if somebody is arrested by the police and then they take him to the police station, discover that they've got the wrong man and release him before there's any question of even seeking police bail, you don't then go off to the High Court to make a bail application. So there's no Article 5 requirement for a speedy review. The question is whether you still go to the court. In this particular circumstances, as a matter of the statutory scheme.
We're dealing with somebody who's conditionally discharged. Have we got that right? In the period, they've gone back to being conditionally discharged. Is that right? So you say Article 5 doesn't apply in those circumstances, do you?
Yes, because that is not detention within the autonomous meaning of the Convention. And if, my Lord, I don't ask you to go to it, but looks at the case of MM, that's a Supreme Court case which says that the Secretary of State can't impose conditions amounting to a deprivation of liberty. So conditional discharge can have conditions attached to it, but not conditions that are so stringent that they amount to a deprivation of liberty within the meaning of Article 5. So that's what the Strasbourg jurisprudence would require. There's a separate question what the Act envisages, which may well be, and in many cases is, reviews of detention in circumstances where there might not be a duty to have it under Article 5.4, any scenario in which someone, for example, applies to vary their conditions. So as far as the question of statutory interpretation is concerned, if the position is that the person is conditionally discharged before a reference has been made at all, that is very quick indeed. That is within a matter of 24 hours or so, typically. It is wholly implausible that that would arise in any scenario other than the original decision to recall being a mistake. And in those circumstances, the Secretary of State's preferred approach would be not to proceed with the recall and then conditionally discharge again. It would be to rescind the warrant for recall. So the power to recall is one which arises under Section 42.3, which refers to the issue of a warrant for recall.
44.
42.3.
42.3.
So rescind the warrant and therefore rescind the recall.
So rescind the warrant, therefore rescind the recall, so therefore the patient is treated as though...
It's never having been recalled.
Precisely. So the existing time limits would continue to apply. In other words, there is no resetting of the clock because it's rescinded and treated as never having happened. So no issue arises in that case because it's as if nothing had ever happened. The second possibility that I referred to is that the recall is made, the reference is made, and the release, conditional discharge, occurs between the reference being made and the reference being adjudicated upon. That is the point on which the Secretary of State does not ultimately resist what the appellant has suggested. In other words, that if the court's view is that recourse to the tribunal in those circumstances is necessary in order to ensure judicial oversight, then the Secretary of State does not seek to dissuade the court from that course.
It would be up to the tribunal what they did with it.
Well, that's the de facto
position. They're still seized of it. The patient has been discharged. Would they have jurisdiction to consider an application by the patient to vary the conditions of discharge?
Well, yes, on the basis that the effect of the reference is that Section 73 applies.
Yes.
And that's effectively the full powers. It is certainly taking a purposive approach to Section 73. That is in common with many of the cases that Malone and Friend cites. if one were to play devil's advocate and ask what might be the grounds on which the court might conclude that jurisdiction does not survive, there are a number of answers to that. One is that subsections 1 and 2 of section 75 are clearly intended to mirror one another. In other words, one deals with the position where a patient's been conditionally discharged and recalled, the other where a patient's been conditionally discharged and not recalled. It's clearly intending to cater for the two competing situations. When one looks at subsection 3, which relates to the position where someone has not been recalled, instead of the full panoply of powers, there is just the power to vary the conditions that have presumptively been imposed and to direct effectively absolute discharge, and not the full panoply of powers under section 73. In other words, clearly the legislation is calling into question whether you need the full section 73 powers, and it might be thought that had the court intended jurisdiction to survive in either case, it would have seen no need to provide for subsection 3, because you could simply refer to section 73 and those parts that did not apply would not apply. And the way that subsections 2 and 3 work together is that if one envisages a scenario in which the patient is recalled, is the subject of a reference which proceeds in the ordinary way while he remains in detention, is adjudicated while he is in detention, and which results in no order for his release. But thereafter, he is conditionally discharged, having presumably made some progress. Then subsection 2 provides that he does not then get to apply to the tribunal to complain about his conditions immediately that they're imposed by the Secretary of State. That opportunity only arises later. So it's not the case that every single aspect of administrative decision making results in automatic recourse to the tribunal. The overarching intended scheme and the usual scheme under the Act is a restriction order is imposed. Obviously, for a restriction order to be imposed at all, one of the conclusions that the sentencing judge needs to reach is that there is a risk of serious harm to the public if restrictions are not imposed. So there is an overarching judicial decision that the general pattern of these restrictions should be applied indefinitely. Now, I don't suggest for a moment that that means that there's no need for subsequent reviews by a court, but nevertheless, that initial decision is important and has been made. Thereafter, a period of detention, a period of conditional discharge, during which initially the patient has no right to call into question the conditions, but then subsequently, after an elapse of time, may do so. And then, if there is no recall, no relapse, one hopes progress will be made to the point at which the patient is ready to apply to the tribunal. But I don't fully accept the premise of my learned friend's point that fluctuating conditions might nevertheless mean that it's essential that there should be a power to apply for absolute discharge immediately after a short period of recall.
You're talking about fluctuating conditions, you mean the patient's mental state, not the conditions imposed.
Yes,
Yeah.
so what he referred to was the situation in which
Yeah.
a fluctuating mental state
Yeah.
leads to very rapid changes of status under the Act. And if a fluctuating mental state leads to very rapid changes of status under the Act, one would have thought a priori that that is exactly the sort of situation in which the Act would envisage that someone should be liable to recall. And therefore, it's not necessarily the case that just because someone recovers very quickly from a condition which, well, not a condition, because obviously the mental health condition is presumed to subsist, but from an episode which led to recall, if there remains a chance that their condition may fluctuate in the opposite direction, the Act envisages a period of stability before you get to the point at which the tribunal will say, all right, well, you've been conditionally discharged for some time, there have been no issues, the criteria are met, and we consider that restrictions should no longer apply. In other words, I don't accept that rapid changes of status are a promising basis for an application for absolute discharge, or that it was the purpose of the Act to achieve that.
Conditionally discharged patient, Secretary of State can vary the conditions under Section 73.
Yes. £73.5.
But the other direction, the scheme of the Act is that the patient has to wait a year.
Right. Yeah. Subject as well to 2 points. First of all, the power of the Secretary of State to refer a patient at any time, which is Section 71(1). That is unrestricted. And an example of the use of that power might be a situation where, for whatever reason, a person had been subject to a short period of recall which, for whatever reason, had not been dealt with in the way that I've indicated. And if the Secretary of State felt that such time as it had elapsed has made it appropriate for the patient to be referred to the tribunal, that could occur. And of course, Section 71 is not subject to the caveats in Section 75 as to the effect of Section 73, so all of the powers would be in place. And the other, and I appreciate that there is a limit to weight that I can put on either of these points, because one is an executive power and the other is legislation still to be enacted, but the other is the backstop that I've indicated in my skeleton argument is expected to be enacted subject to any further parliamentary scrutiny, which effectively provides a long stop of, I think, 3 years when, if a patient has not been referred to the tribunal, they must be. My Lords, I don't have anything else to say on the subject of the interpretation of Section 75 following a reference being made. I only invite my Lords to consider whether it's appropriate to decide that question or not. On the substance of the appeal as it was pleaded, there is really very little that I have to add to the submissions that I have made in writing. One point that has not been thrashed out by either me or my learned friend to date is the relevance of the case law considered in the round. My Lords, I would take only the following observations from the case law. The first is that no single rule applies as to whether an application survives a change of status under the Mental Health Act generally. And therefore, whatever other decision my Lords may make, I would submit that the points made by my learned friend about guardianship can be disregarded, because it's entirely clear, and indeed it's a point that my learned friend relies on in other contexts, that the case law does not admit of a single answer to the question whether jurisdiction survives a change of status. Secondly, I make the point that nearly all of the cases which deal with that issue involve scrutiny of Section 66 and Section 72, which implements it. The reason why I say that that is significant is that if my Lords look at Section 66, which is at page 69 of the Authorities Bundle, what we see there is the opening word where in subsection 1, followed by a whole great list of circumstances from A to H, including various inserted letters, and where any of those conditions applies, an application may be made to the appropriate tribunal within the relevant period. And even as between different changes of status within Section 66, the cases have not spoken with one voice. But Section 66 in my submission gives the ground for a better argument that jurisdiction should survive a change in status on the basis that the status is an application. The measure in question is an application, and what is changing is the gateway, rather than the situation that we're dealing with here, where the question is whether an application survives when a referral needs to be made. In other words, it's more obvious that where an application has been put in on one basis under Section 66, it might be said that the change in gateway does not extinguish the application. So the fact that nearly all of the case law is dealing with that provision means that I say that my lords can essentially disregard it. Safe to note the point that my learned friend himself makes, which is to be wary of expressing any view on the other provisions of the Act. As far as statutory purpose is concerned, I'm not sure, in light of the questions that have been addressed to my learned friend, there is really anything that I can usefully say. The Secretary of State's position is, first of all, that a referral under section 75(1) is on any view mandatory in the circumstances where it has to be made, and thus there is no question of dealing with matters by not making a reference. And secondly, that if a reference is being pursued, then any application will consider either the same test as my learned friend submits under section 73, or if the view expressed by my Lord Justice Males is right, a more restricted test in addition to the test which applies under the reference. But on either view, it can add nothing. There is nothing else I positively want to draw to the court's attention.
The Tribunal Judge Jacobs referred to the rules in paragraph 25 on page 87 of the bundle. We haven't got the rules, have we? In our authorities, I don't think.
We haven't.
What does Rule 17.3 specifically say? What he says, it says the Secretary of State is prevented from withdrawing the case on the reference.
Yes, well, I certainly accept that is right. The reference, once made, goes off into the ether. The Secretary of State would notify the tribunal if there was a change in circumstances, but that would be for information, and it would be for the tribunal to decide what to do with it. I'm sorry, I didn't quite get the reference. Was it section? Was it
page 20, paragraph 25 of the Judge Jacobs' judgment? Paragraph 25. He talks about Rule 17.3.
I'm sorry to interrupt, but my lord, if it helps, I have a book here with the rules in it.
Well, I think the Lord's got it. The Lord's got it too.
Jones,
Yeah.
And I could look at it on my computer. I'm being very lazy.
Okay.
2025
I was hoping
edition.
that Miss Ailes might be able to have it.
If you have the page reference, do.
795 in this edition, but I think you might have a different edition.
Well, there or thereabouts.
Yeah.
Yes.
Which rules are they?
Tribunal Procedure Rules, 2008.
Thank you.
A party which started a mental health case by making a reference to the tribunal under section 68, 71(2) or 75(1) of the 1983 Act may not withdraw its case. A party which has withdrawn its case may apply to the tribunal. place to be reinstated. So, anyway, once a reference has been made under section 75.1, it's entirely within the control of the tribunal what happens to it.
Yes. Although, of course, if it has no jurisdiction to deal with it, then it must strike it out.
Well, yes.
But nobody's suggesting that there's no jurisdiction to deal with the reference. It's
Certainly
an
not.
application.
Does that provide any support from my Lord or Justice Mills's interpretation or proposition as to the interpretation of section 75.1?
It does, with the gloss that there is also always caution to be exercised in relying on subordinate legislation and rules as to the interpretation of primary legislation. But yes, it does convey some insight into the way that the scheme is intended to work.
Yeah, the rules come quite a lot later than the Act, in fact.
They do, yes.
You know what the predecessor said. We can tell. Yeah.
Well, it wouldn't. Section 75.1 would not provide much of a protection to the patient as required by Rayner if a reference could be made and then withdrawn a week later.
No.
Yeah. All right. Any question? Thank you. Any question? Thank you very much. Mr. Bezzani, no need to repeat anything, but is there anything?
I don't think there's anything
Like
I
you
can
said.
use to the Admiral.
Right. Thank you all very much. It was as close to a seminar as I had in this court, but the jurisdiction point is important, even if with no great practical consequences for the appellant. We weren't given in the bundles the FTT decision of December.
Would you like it, my lords?
Yes, please.
I'm handing up the full permission bundles because they're only 40 pages long, but the FTT decision is it's from memory at page 10.
Well, we
Yes.
probably we shouldn't have a great pile of stuff which Mr. Bezzani and Mr. Percy haven't necessarily seen. I'm sure there's no objection to seeing the FTT decision. I would normally expect it to be in the bundle, but
No.
I don't believe there's anything else that isn't in the bundle, but perhaps I'll have a check.
yes.
It's your permission bundle.
The one that you've got here.
Yes, I'm sorry, my lord, I hadn't realised that until
It's all
last
right.
night
No,
either.
not criticising anyone.
Fourth of December decision isn't in here.
Hang on.
4th of December CD. It's not.
Oh no, not the conditional discharge decision.
No.
Sorry. Have we been talking about cross purposes? I thought you were asking for the FTT decision on the reference.
Oh no. Well,
No.
the one which was the subject of the appeal to Judge Jacobs, Judge Chamberlain's decision. That is in the bundle. Yes.
No, the separate decision of the FTT on the reference,
Yes.
deciding to keep the appellant in detention, was what I thought you were asking for. Jurisdiction was refused on the application, that was struck out, but the reference obviously survived, was determined against the appellant by the FTT.
I don't think that's even in the chronology. Yeah. I'd certainly like to know that decision was made and when. 1st of March, decision to recall. 5th of March, reference made. And that we were told on the 4th of December, the FTT decided that the appellant should be conditionally discharged. You're saying there was an earlier...
There was an earlier decision because the tribunal decided it lacked jurisdiction on the application because
Yes.
of the reference.
Yes.
The reference was set down for a hearing on the 18th of April 2024.
Yes.
That was subsequently adjourned to the 25th of July.
Yes.
There was an oral hearing on that date at which release was refused. The conclusion was announced at the hearing, which was by video link.
Just a moment. And that wasn't the subject of an appeal.
Not as far as I know. Reasons
then-
given, finally, 26th of July, the day after the hearing.
26th, right. Yes.
Can I assist on this? Because I've got the list for my I've got a list of the decisions and their dates,
Yes.
which end up with the decision to discharge or conditional discharge.
On the 4th of December.
Yeah, so the 25th of July 2024 was the decision on the reference,
Yes.
decision no discharge. Application made on the 5th of September,
Yes.
and then conditional discharge on the 4th of December, if that tallies.
All right. Well, that's fine. So there were two substantive decisions of the FTT. One on the 26th of July, following a hearing the previous day, refusing release, and then 4th of December, ordering conditional discharge.
Yes.
Thank you very much. We will follow the usual procedure. We'll send out a draft judgment in the usual way. Draft, not in the sense that we seek further argument, but draft only in the sense that you'd like any obvious factual errors such as dates and so on to be corrected. We will then hand down the decision formally. It's not the draft decision may of course be communicated to the appellant and to anyone within the ministry who needs to know in order to give instructions, but is not otherwise to be publicised until the formal hand down and publication on the National Archive, see Counsel General for Wales and all that. You know all that. Thank you all very much for your assistance.
Court rise is able.